I wonder if it would be useful for me to describe what the world of water rights would look like for wild horses if this bill were to pass. I don't know if that's something you'd like to hear about, or you want to hear more.
That would be great.
I would agree with what Mr. Busselman said in terms of if this bill were to pass, it would not impact the watering of existing wild horses and burros. I mean, it would be impractical to think that that would stop. I would also point you to a statutory provision, 533-367, that states that, well, that provision allows wildlife which customarily uses water from a spring or seep will have access to that spring and seep. I think that statutory provision arguably allows wildlife that has customarily used it to continue to use that. Moving forward, if the bill were to pass, what that would say is that our office would no longer be able to issue a water right for wildlife where the wildlife include wild horses and burros. However, there's been much discussion about, for example, mandolin pickers who may come in and get access to public land or may buy private land. We believe under our statute we would be able to issue water rights for livestock to someone like that is managing those wild horses on that land. So if you were to buy some private ranch land and had livestock water rights, we believe under the definition she would be able to have water rights for those wild horses. Thank you.
Do you see any legal ramifications in your point of view?
Jason King for the record, Mr. Chairman. I mean, everything is fraught with, you know, some, I think, legal ramifications if you want to twist the definition of livestock. You know, this certainly makes it crystal clear in terms of definition for wildlife. But no, I guess I'm going to backpedal. The language that's in there, I think it's okay. I think it gives our office the ability to issue water rights for livestock that would include them, and again, our existing water rights for wildlife would continue for the wild horses and burros. So I guess I'm backpedaling and saying no, I don't see a problem.
And just, if this bill doesn't pass, run that by me again. Where we are today, I mean, where are we tomorrow if this bill doesn't go anywhere? What are we doing? What challenges do we face, if any? I mean,
Jason King for the record. Mr. Chairman, if this bill doesn't pass, then we're back to the status quo, and that is, it would be our policy that we could issue wildlife permits to BLM for the watering of wild horses and burros if the place of use is in a herd management area. If it's outside a herd management area, it has been our policy that we haven't issued that. So we would continue to do that. Now, I will say that, again, an application would be filed. It would be in publication for 4 weeks, 30-day protest period. People could come in, whomever, and want to protest that for whatever reasons, and we could run it through, you know, the courts that way.
So if someone were to come in, wanted to do a sanctuary, what would be the process if this bill passes then? What kind of obstacles would that person or persons have?
I think the obstacles would be,
if this bill passes.
If the bill passes, again, Jason King for the record, Mr. Chairman. The obstacles we would now be issuing water rights for wildlife purposes to issuing water rights for livestock purposes. And under that definition, the applicant that's making the filing, bear with me one moment, must be legally entitled to place that livestock on the lands, owns, leases, or otherwise possesses a legal or proprietary interest in the livestock. So there's those conditions. We would want to see, someone wants to create a sanctuary, we would want to see probably some kind of piece of paper that looks like they are there to manage the wild horses. And I'm not sure what that looks like, but if we see that there's this agreement for that person to run wild horses in the sanctuary, we believe we could issue water rights for livestock. If it was in a basin that wasn't fully appropriated, they could file for a new appropriation and we could issue a water right. If it's fully appropriated, they could purchase water rights, file a change application for livestock. Clear as mud.
Sounds like another road trip, right? You ready? Go. Okay. All right. Questions, committee? Okay. Don't go far. We might have some more later. Go ahead.
Thank you, Chairman Menendo and members of the Senate Natural Resources Committee. Thank you for your time today. For the record, my name is Jeremy Drew, and I serve as the director for the Coalition for Nevada's Wildlife. The coalition is comprised of and represents leaders of a broad cross-section of sportsmen and wildlife conservation groups across the state. We wish to express our support for AB 329 and thank the bill's sponsors for their support. This bill provides clarity and consistency of the term wildlife. This bill also helps protect state-managed resources. While we fully appreciate the wild horse as a living symbol of the West, overpopulation of these animals have adversely impacted other valid multiple uses on public lands. Wild horses are a non-native species that are large, strong animals. They simply outcompete our native wildlife for forage and water. The Nevada Department of Wildlife and sportsmen in the field have repeatedly documented wild horses monopolizing critical water sources and preventing antelope, bighorn sheep, deer, and even elk from utilizing spring sources. The overutilization of riparian areas has been detrimental to both terrestrial and aquatic wildlife. These impacts have been repeatedly documented, even in areas that are completely absent of livestock grazing, such as the Sheldon National Wildlife Area. Nevada supports over half of the nation's wild horse population. Over half the herd management areas in Nevada are over appropriate management levels. Many are double or triple those appropriate management levels. This is in direct conflict with the 1971 Wild Horse and Burro Act. In order to achieve and maintain a thriving ecological balance, the Act mandated the BLM to remove excess wild horses above appropriate management levels. These levels are established by scientific determinations of available resources, both water and forage. The BLM has continually demonstrated its inability to control wild horse populations within its designated HMAs, as well as preventing the spread of wild horses beyond those areas. Since passage of the 1971 Wild Horse and Burro Act, the BLM has never reached appropriate management level throughout the state of Nevada, and we are currently far from a thriving ecological balance. Further exacerbating this issue is the recent BLM draft strategy for the future of wild horses and burros. The strategy suggests further expansion of wild horse populations, both in number and range, while acknowledging an expected reduction in wildlife populations. I should reiterate the fact that while the federal land management agencies have explicit management authority over the wild horses and burros, the state of Nevada retains management authority over wildlife. The bill does nothing to limit existing water rights to wild horses within designated herd management areas. This bill gives the state engineer the ability to separate and protect our state-managed resources from an ever-increasing problem of uncontrolled expansion of federally managed wild horses and burros. This bill makes consistent and clarifies that the state does not have management authority over wild horses and burros as it does with all other wildlife. Thank you. I'd be happy to answer any questions.
Thank you, Mr. Drew.